Let's talk about the legal liabilities of these tax preparers, specifically contracts. Well, when a CPA enters into a contract with a client, now, I mean, this is not even a big formality, right? If you're just doing a simple tax return that's going to take you an hour for someone, I mean, that's technically a contract, right? When obviously we get into contract law, we have a whole lesson on that. But when you enter into a contract with a client, you agree to provide specific services as outlined in the engagement letter. Now, like I said, it could be as simple as a tax return that's going to take you an hour, or it could be something a lot more complex, like a tax return that might take you 40 hours. Maybe they have 5 businesses, they've got 15 kids, and they've got 20 homes. It's just there's can be a lot of complications and serious implications on how your tax return comes out. So this can include preparing tax returns, providing financial advice, or conducting audits. Any of this, right? We said this can apply to audits as well. You could be doing tax advice. You could be spending hours on the phone advising them on what they should do for tax purposes. The client expects the CPA to perform these services with due diligence, competence, and in a timely manner. You're going to do your research, make sure you're not just recommending things for the sake of recommending them. You're going to be competent, you're going to actually know what you're talking about, and do it in a timely manner. We'll see examples where if they say, I need a tax return by April 15th, and you don't have it by April 15th, well, that's a breach of contract, a breach of duty. Now, if a CPA fails to fulfill the terms of the engagement, the client can hold the CPA liable for breach of contract. Again, this is something we'll see here and something we'll see in very much later in our contracts lesson. In legal terms, a breach of contract occurs when one party fails to perform their obligations under the agreement, resulting in harm to the other party. Contract liability generally requires privity, which means that only a party to the contract can sue under a contract theory. In other words, if the third party's harmed due to a CPA's failure to perform their obligations, they typically cannot sue the CPA for breach of contract because they were not a party to the original agreement. We'll see this example and we'll see contradictions, exceptions, and all that. If this tax return is prepared and then there's a bank that is relying on the tax return to see the financial situation of the person who the tax return was prepared for, that is a third party. There's many examples. Maybe in one example, the CPA does know the return is being prepared to show to a bank. In that case, the CPA may have liability to the bank. If the bank loans the money to the taxpayer and the tax return was prepared incorrectly, meaning that the person doesn't really have the money they said they did, and as such, the bank gave them a loan, the loan was defaulted on because they couldn't pay it. So that's just one example there, where that's a third party, and if the CPA knew that it was going to a bank, the CPA could be liable to the bank as well as the taxpayer, if they mess up on the return. If they don't know that there's going to be a bank involved, then you probably won't be liable. Breach of contract and torts. Tort law is a big thing. We'll see that as well in our business law. Civil actions for tax malpractice arise when a tax professional fails to meet their obligations to their client, which results in harm or financial loss to the client. These cases are generally based on contract principles or tort principles. We'll see the difference here. In a tax malpractice case based on contract principles, the focus is on the agreement between the tax preparer and the client. The tax preparer is expected to prepare the client's tax return diligently and competently. Seen that a few times. Do your due diligence and be competent, so make sure you know those. A breach of this contractual obligation may lead to a malpractice claim if the client suffers a loss as a result. So your job is to do your job. That's your job. Get a good tax return out there. And if the client gets sued by the IRS because you did a bad job, or the bank sues them because they have a faulty tax return, that's a big problem. Now, tort principles in a tax malpractice case based on tort principles, the focus is on the duty of care that the tax professional owes to the client. This duty requires the tax preparer to exercise the same level of skill, care, and diligence as other members of the profession under similar circumstances. So your job is, if a normal CPA would have done the due diligence with what you did, then you're screwed. But let's say a normal CPA wouldn't have thought to look up the tax implications of some rare cryptocurrency and understand how that applies. Maybe you're off the hook. That's kind of what we're talking about here. A breach of this duty may lead to a malpractice claim if the client suffers harm as a result. With cryptocurrency, that is a great example I will continue to use. Maybe you're watching this at some point in the future and somehow the IRS has a handle on what cryptocurrency is and how they should tax it. Maybe, and if that's the case, then just remember that in the beginning, it was an absolute mess. Malpractice. Okay, this is important. I want you to memorize these. To successfully prove tax malpractice against a tax preparer, the plaintiff, which is usually the client, and why do we say that? Because this could also be the bank in those examples we talked about, they must establish the following elements. So make sure you memorize these 4. that you need these for, and also make sure you understand what they are. So first is that there's duty, which means there's the existence of a valid contract. First off, there needed to have been a valid contract. I mean, if there wasn't a contract, then you can't sue someone. You can't just sue everyone. You can only sue people that you had a contract with. Well, I'm not a lawyer. I'm not getting into that. The tax preparer owed a duty of care to the taxpayer. This duty is typically established through the professional relationship between the preparer and the client, or by the applicable laws and professional standards. So just they have a contract. Breach of duty. The taxpayer breached the duty of care by failing to act with the necessary skill, care, and diligence. This could involve errors in preparing the tax return. Again, if it's an error that you can prove to the court that no one else, a reasonable CPA would not have caught, then you might be off the hook. But if it's something stupid, yeah, you're on the hook. Failing to meet filing deadlines, that's a no-brainer. I mean, if you're late, that's pretty much you're at fault. Or giving incorrect tax advice, that's a big gray area. That could basically be on absolutely anything from the tax implications of selling your house to buying a business and anything in between. Next up, injury. The plaintiff suffered an injury or financial loss as a result of the tax preparer's breach of duty. If this whole situation resulted in no damage, then there's nothing really to sue about. But if there is injury, that usually will include penalties and interest imposed by the IRS, additional tax liability or costs associated with rectifying the error. Maybe they had to go get another tax accountant, competent one that actually cared, to properly do that. Those would be additional costs you may have to cover. Lastly, causation. There must be a direct link between the tax preparer's breach of duty and the plaintiff's injury. Let's say you completely mess up their Schedule C, but they're getting sued by the IRS because they're Schedule D. That there would be something to say there that you were not at fault for that. The plaintiff must show that the injury would not have occurred if the tax preparer had fulfilled their duty of care. Lastly, if a plaintiff can prove all these elements, it's got to be all of them. If you're missing one, you don't have a case here. They may be entitled to recover damages from the preparer for the harm caused by the malpractice. Boom, boom. Make sure you know this slide. It's going to be important. Hey there. Are you ready to not only pass your CPA exams, but truly understand and enjoy the material while studying? I know it seems impossible, right? Especially to enjoy the material. We'll do it together. Tap into the power of CPA.examprep.ai, where we've got personalized quizzes, multiple choice questions, memorization guides, flashcards, simulations, all tailored to your learning. Our adaptive study planning puts you on the fastest path to success and lifts you back up if you fall behind. Avoid wasting your precious time and money attempting an exam with a low chance of passing, because who wants that? We want to get you through this process as quick as possible. Our exam readiness prediction lets you walk in with confidence, knowing that you're prepared for success on exam day. Thankfully, there's no payment method needed to get started, so why don't you come join us? Visit cpa.examprep.ai and let's achieve your exam success together.